All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
Let's step into the courtroom. The judge calls the room to order, and Mr. Thornton rises to speak. He explains that he's been raising his son, AJ, and consistently sending support payments to AJ's mother, Ms. Hernandez. But recently, things have taken a serious turn. AJ has been caught up in dangerous behavior, including a burglary and a police chase that ended in a crash. The judge listens closely and asks if there have been any major changes at home or financially. Mr. Thornton, visibly worn down, shares how AJ's actions have pushed him to the edge, emotionally and financially. He's not just talking dollars. Here, he's talking about the pressure of raising a troubled teen and trying to do the right thing. Now it's up to the judge to weigh the facts and decide what comes next in this difficult case.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
If I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
Mr. Thornton lays it all out before the court. He explains that Ms. Hernandez has moved out of state, quit her job, and her health insurance no longer covers AJ. That leaves him carrying the full financial weight. Medical bills, court fines, and even costs from AJ's accident. But the judge quickly brings things back to the legal agreement. She reminds him that during mediation, both parents agreed there would be no child support. So now the court needs to see, has anything truly changed? That's where things stall. Mr. Thornton can't prove a significant shift. AJ has always lived with him, and nothing in the legal framework has drastically changed. You can feel his frustration building as he runs into wall after wall of legal requirements. It's a powerful moment that captures the strain of being a single parent, trying to do the right thing, and hitting a system that won't budge without concrete proof.
In that aspect, and the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay, here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed, but in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just...
The judge takes control with a steady, no-nonsense tone. She explains that in order to modify the child support arrangement, there must be a clear and meaningful change, whether it's a shift in income, living situation, or educational needs. But in Mr. Thornton's case, she points out, nothing substantial has changed since the original agreement was made. That agreement still stands. Mr. Thornton, visibly upset, argues that Ms. Hernandez has walked away from all responsibility. He feels the system is letting her off the hook. Still, the judge stands firm. She reminds him that both parents willingly agreed to the terms during mediation, and the law requires significant change before anything can be altered. Her ruling is precise, unwavering, and rooted in legal precedent. No room for emotion. It's a striking moment, a parent's desperate call for help crashing into the rigid framework of the law.
Free of any obligation? I mean...
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you,
Okay,
Your
is there
Honor.
anything further?
No, ma'am, not at this time.
Okay,
That's about it.
okay. Well, if there's nothing further, you're dismissed.
Thank you.
You're welcome.
The judge delivers her final decision. Given the current facts, Mr. Thornton will not receive child support. She firmly states that the original mediation agreement still stands, and with that, the case is dismissed. Mr. Thornton nods respectfully and thanks the judge, but it's clear he's leaving the courtroom discouraged, still carrying the full weight of AJ's financial needs. The judge's closing words drive home a tough reality. Unless there's a major life change, legal. Agreements can't be altered, and just like that, the courtroom drama ends. But the message lingers. Let's break it down legally. A family law expert explains that in Texas, modifying a child support order requires what's called a material and substantial change, like a shift in income, custody, or educational needs. Since none of those applied in Mr. Thornton's case, the agreement held firm. As the video wraps, viewers are reminded child support laws are complex, and trying to navigate them without legal help can make things even harder. If you're in a similar situation, don't face it alone. Talk to a legal professional. And if this case hit close to home, share your story in the comments and subscribe for more real-world legal insights. Because when it comes to family law, knowledge really is power.